Honorable Justice K.D. Damlak, dated this 4th day of March 2022, suit number NICN/IL/OX/2019 between Ibrahim Adio Badiru, claimant, and University of Ilorin, defendants. By a general form of complaint filed on 26 August 2019 and accompanied by the documents required by the rules of court, the claimant claims as follows. A declaration that the absence of Mrs. Bose Falaye, the security men, and other witnesses at the disciplinary committee hearing of 25th day of June 2018 denied the claimant the opportunity to cross-examine them. And B, a declaration that the absence of Mrs. Bose Falaye and the security men at the disciplinary committee hearing of 25th day of June 2018 and the denial of claimant right to fair hearing. Of course, this prayer B is incomplete, is incomprehensible. C, an order of court declaring the disciplinary committee proceeding of 25th June 2018 leading to the dismissal of the claimant as illegal, unconstitutional, null and void for being in breach of claimant's right of fair hearing. D, the declaration that the defendant's disciplinary committee acted as the prosecutor and judge in the same matter, resulting in glaring miscarriage of justice to the claimant. E, an order of court reinstating the claimant to his position as a staff of the University of Turin with full payment of arrears of salaries from 10th October 2019 till date, along with other benefits, or in the alternative, conversion of the dismissal to retirement with full benefits. F, an order of perpetual injunction restraining the defendant, its agents, or privies from revisiting the alleged misconduct stroke offenses, and for such further orders as the Honorable Court may deem fit to make in the circumstance. The defendant filed a memorandum of appearance and statement of defense by a motion of 19 February 2020. Facts of the case. The claimant was the staff of the defendant from the year 2000. In 2008, he was accused of admission racketeering. He faced disciplinary panel and was subsequently dismissed. Case of the claimant is that one Bose Falaye approached him asking for assistance for admission for her daughter, told her he was not in a position, but that after some times he saw an alert of 60,000 from Mrs. Bose into his account, that he wonders how she got his account number. After some days, she sent some materials, some items to him in his office, and that when the dean called him, he told him so. He refunded the money and the items. They wrote statements in the security post. It was after that he was queried and then attended disciplinary committee. At the disciplinary committee, they said Mrs. Bose was not called to testify. The other officers who made statements were not called. The security men were not called either. That is the whole story of the claimant. The defendants on the other side, their own case is that the man actually promised Mrs. Bose Falaye and collected money from her to assist her get admission for her daughter, and that will tarnish the image of the institution, and that the claimant was afforded fair hearing. board council submitted final written addresses to convince the court why judgment to go their own way. Court's decision, admissibility of Exhibit OM1. The complaint of the claimant counsel on the admitted Exhibit OM1, which is report from the office of the CSO, is that the document and all its attachments are inadmissible in evidence. They are public documents, but were not properly certified as required by law. The documents OM1 and the attachments were not properly certified, as the endorsement certificate was not dated and the name of the officer was not stated. The signature and official title is visible, but no date, no name as required by law. The reply of the defendant's counsel is that Exhibit OM1 is a certified true copy of the report of the security unit of the defendant. Especially the said document, there is an endorsement of certification. The name of the officer certifying it is boldly written, same was signed, and the designation was also written boldly on it by the provisions of Section 12(2)(b) of the National Industrial Code Act 2006 and Order 9(2) of the Rules of Court. Always been that the Honorable Court may depart from the rules of evidence to do substantial justice. The claimant himself confirmed existence of Exhibit OM1 in paragraph 17 and 18 of the Statement of Facts. He also confirmed it under cross-examination when he was asked whether they all made statements before the security post. He answered in the affirmative. Is the evidence of the claimant that they were taken to the security post and Mrs. Bosefalaye made a statement there, and under cross-examination, he testified that I went to security post by myself. I met Mrs. Falaye at the security post. I met Ayo and Professor Agunu also at the security post. All of us wrote statements at the security post. The pertinent question now is whether the absence of the date and the name of the registrar, the certifying officer, renders Exhibit OM1 inadmissible in view of the admission of the existence of such document by the claimant, and whether or not this court can, in the interest of justice under Section 12 of the National Industrial Code Act 2006, depart from the requirement of Section 1042 of the Evidence Act 2011. On the first question, whether the absence of the date and the name of the registrar, the certifying officer, renders Exhibit OM1 inadmissible in view of the admission of the existence of such document by the claimant. On Section 104 of the Evidence Act, the Court of Appeal held in His Royal Highness Oba Ayodele Adetunji Ajayi and another versus Pastor Z. Akindahumsi and others, 2019 LPLR 4791 CA 47912 CA as follows. The above provisions was interpreted by the Supreme Court in the case of Topic Investment Limited versus PLC 2011, page 1592, amongst other cases where it was a document can be tendered and accepted by the court. It must be certified. Public document is certified if A, it was paid for, B, there is an endorsement or certificate that it is a true copy of the document in question. C, the endorsement stroke certificate must be dated and signed by the officer responsible for certification. with his name and official title. On the authority of the above decision, it appears that the absence of the date of certification and the name of the certifying officer renders the certification effective. On the second question, it is the firm view of the court that in view of the fact that the document exhibit MO1 is a CTC of the report of the Chief Security Officer of the defendant submitting the said written statements of the claimant, Mrs. Bosefalaye, Ayo, and Professor Abunu, which was admitted in evidence without objection. The claimant did not deny that those were the statements the four of them made at the security post, rejecting the document only for the absence of the date of certification and the absence of the name of the said registrar who certified it will not be justice, but replacing justice with legal technicality on the throne. I hold that the interest of justice is in favor of the court, departing from the strict requirement of Section 102, sub 2 of the Evidence Act 2011 under Section 12 of the National Industrial Code Act 2006, and I sought the part and admit the document and decline from expunging Exhibit M01. Admissibility of Exhibit OM2 tendered. MO2, sorry. Exhibit MO2 tendered. The complaint of the claimant's counsel on the minutes of the disciplinary committee meeting of 15th April 2018, 25th and 26th June 2018, admitted and marked as Exhibit MO2 tendered. Is that an unsigned document is not admissible in evidence. No signature, not even the name of the maker of the document is indicated on Exhibit MO2 tendered. That the said Exhibit MO2 tendered was purportedly a certified true copy. The such certification, even when properly done, does not make the unsigned document admissible in evidence. The unsigned document is worthless. The defendant's counsel adopted his submission on Exhibit MO1 and added that once it is shown that same is a certified true copy of a document, the requirement of signing as is unnecessary. The fact of the committee is not denied by the claim. The very proceedings of the committee that the claimant is alleging did not afford him fair hearing. Without the said report, the court wonders how the claimant intends to assist the court in reaching an informed and fair decision on whether or not he was granted fair hearing at the committee's proceedings. The complaint of the claimant is not records of the committee, is the absence of the signature and name of the maker of the document. Inside the Sanusi and others versus Tunde Isheku and others, 2017, LPELR 43160CA, the Court of Appeal for Ugo JCA held a certified true copy of a document as opposed to the original from which it is copied and certified does not need to bear the particular public officer or maker's signature, as it is the certification that authenticates it. A similar argument like the present one of appellants was rejected by the Apex Court in Ahmed versus CBN 2013-11 Nigeria Report Part 1365-352 with Onogen JSC, as he then was, saying at pages 373 to 374, paragraph G to H, also reported as Ahmed versus CBN number 2, 2013, 56 SC, part 1, page 132 and 162. It is their contention that Exhibit F, the certified true copy of the judgment of Justice Ariwala JSC, was not signed, nor was it dated by His Lordship, thereby rendering this is not as Exhibit F is nothing but a certified true copy of the original judgment of His Lordship delivered on the 6th of March 2012. Lordship is not expected to sign a certified true copy of his judgment. In fact, the practice is not for a certified true copy of a document to be signed at all. It is the certification by the and adding for good measure that the judgment of His Lordship was not signed. The proper thing to do is to establish that fact. The proper thing to do to establish that fact is to exhibit the original copy of the judgment, not a certified true copy. The document Exhibit M is accordingly admitted in evidence and marked as Exhibit M02. Merits of the case. Learned Defendants Counsel has contended that, and I quote, the only way the claimant can conveniently show to this honorable court that the termination of his employment was wrongful and must be set aside, and how such man did not plead, neither did he tender his letter of employment nor condition of service, which is the contract between him and the defendant, leaving your lordship in the dark as to whether his employment is one that required compliance with the rules of fair hearing, quotation end. It must be noted that it is an avoidable blunder for a claimant who is claiming unlawful termination to come to court without his letter of appointment and the defendant's condition of service. However, it is not the letter of appointment or the condition of service that confers on him process. Particularly, as in this case, the claimant is alleging that his right to fair hearing under Section 36 of the Constitution has been breached. The claimant can still establish a breach of his right to fair hearing under Section 36 of the Constitution without the appointment of condition of and every employer, private or public, in disciplining its employee, Federal Republic 1990, or determination by or against any government or authority, a person shall be entitled to fair hearing within a reasonable time by a court or other tribunals established by law in such manner as to secure its independence and impartiality. Fair hearing means a trial conducted according to all the legal rules formulated to ensure that justice is done to the parties to the cause. It does not matter whether the panel is administrative or quasi-criminal panel or body. Cases of I.R. Ariori and others versus Moraiwo, B.O. Bello cited there, Obasi, Chief JLE Duke versus Government of Cross River State and others cited there. Galagima JSC, who said, in other words, equal opportunity must be given and accorded all sides to the dispute before a court of law or before the disciplinary committee, administrative panel, and the likes, in accordance with the dictates of and given opportunity to defend himself before a court or tribunal, the proceedings of court, tribunal, panel, or that a nullity and will be vacated or set aside forthwith. Disciplinary, which was not contrary to the executive of this country, disciplinary committee like the one set up to deal with the respondents' employment and the quotation. Also in Garba and others was the University of Maiduguri, 1986, 2 SC, 127 and 128. It's also a report by the King. Correlated view is that fair hearing, even in an administrative court or a disciplinary investigation panel, as the one set up by the Vice Chancellor, implied in the applicant to know what were being alleged against them, what evidence has been them, and they must be given fair opportunity and contain evidence. It also for hear evidence or receive representation behind their backs. The case that brings this clearly case of Kanda versus government quotation and COAO, Igbinova and Delta Steel Company Limited, 1994, LPLR 22949CA. The crux of the claimant's case is one of fair hearing at the sitting of the disciplinary committee. The elements that constitute want of fair hearing, according to the claimant, are: 1, Mrs. Bose Falaye, the Dean of the Faculty of Pharmaceutical Sciences, Professor Abdul Karim Agunu, and the security men were not called as witnesses, so he had no opportunity to cross-examine them, and the request to call Mrs. Bose Falaye was ignored. That's the first complaint. It is considered by the defendants that Mrs. Bose Falaye was not called by the committee. Neither was any of the security officers called. However, it is in evidence that Professor Abdul Karim Agunu testified before the committee. See pages 7 and 8 of Exhibit MO2. On page 8, after the testimony of Professor Abdul Karim Agunu, the claimant was asked if he had any question for the professor, and the claimant said he had none. The disciplinary committee of the defendant was a quasi-judicial panel, or rather was performing a quasi-judicial function. In Muntari Abdullahi versus the state, 2019 FPR, the court held the contention of the appellant that failure to call Ekene Eze, which he regarded as vital witness, to testify, and non-tendering of his statement is fatal and amount to withholding evidence pursuant to Section 167B Evidence Act 2011 is untenable. Let me quickly state without much ado that there is no law that compels the prosecution to tender the extrajudicial statement of his witness. If it is favorable to the defendants, it is his duty to request for it. See cited case of Rosaki versus State 2011, 16, Law Report Part 1278, page 251 at 294, quotation end. It does not lie in the mouth of the defense to urge the prosecution to call a particular witness, as there is nothing stopping the accused himself from calling such witnesses when defense opens. See Okoroji and State 20025 Nigeria Law Report Part 758-21. It is the prerogative of the prosecution to call only witnesses it considers relevant to this case. See Atta and others versus State APLR citations supplied. See also Petco Oil and Gas Limited versus FDN citations supplied. If the claimant felt that the testimony of any witness, Mrs. Bosefalaye or the security men, would help his case before the committee, it was his duty to call such witnesses or to request that such persons be reproduced for their testimonies and cross-examination. On the allegation that the request to call Mrs. Bosefalaye was ignored, the evidence of the claimant before the disciplinary committee is on pages 4 to 7 of Exhibit M02. There is nowhere the claimant asked that he wanted Mrs. Bosefalaye to be called to the committee to testify. On the contrary, claimant testified under cross-examination that I have no evidence to show that I requested for Mrs. Falaye to be called. This allegation accordingly fails. 2, the second complaint is that 2 witnesses, Mr. Amali and pharmacist Abdullahi, testified before the disciplinary committee in his absence, and he had no opportunity to cross-examine them. Exhibit M02 shows that Mr. Amadi did not testify before the committee, but pharmacist A. Abdullahi testified before the committee, as shown on pages 8, 9, and 10 of Exhibit M02. After the testimony of pharmacist A. Abdullahi, the claimant was asked if he had any question for pharmacist A. Abdullahi, and the claimant said he had none. The allegation that witnesses testified before the committee in the absence of the claimant is contradicted by Exhibit M02, and the allegation fails. In the event that the court is wrong in the above allegations, will remain a mere ipso dixit of claimant in the absence of the proceedings of the committee, which he complains against, and his allegation will remain unproven for want of 3. The disciplinary committee acted out the committee and judge is not disclosed in the pleadings and evidence of the claimant. It is in his counsel's final written address that this allegation is explained as follows. And I quote counsel: the absence of Mrs. Bosefalaye and others at the sitting of the DSC, that's the disciplinary committee, led to a one-sided trial where the disciplinary committee became the prosecutor, the complainant, and the judge in the same trial. For the same reason, in deciding the claimant's first complaint above and relying on the same authorities, this allegation also fails. On the whole, for the avoidance of doubt, the claimant did not prove his case. His entire case fails and is accordingly dismissed. each party to bear its costs. This is the judgment of the court. Yes, I see that Saliman has now joined. Can I take your appearance, Saliman? Saliman, leave your phone and announce appearance.
And my name is A.M. Saliman.
S.A.
A.M. Saliman. A.M. Saliman. My Lord, I took appearance before. It was for the defendant.
You are for the
defendant, my Lord.
Okay, thank you. Okay.
Abolarin. We are grateful, my
I
Lord.
have read my judgment. What do you say? Saliman, what do you say?
We are grateful for the well-considered judgment, my Lord. We pray that Almighty God will continue to be with my Lord.
Thank you. Has Abolarin left?
He's on the.
Thank you. Has Abolarin left?
He's online. The network has not been good. I even announced my appearance before, but I don't know that my Lord does hear me.
Today is Friday. Today is Friday. You can get a copy of the judgment on Monday.
We are grateful, my Lord.
You can get a copy of the judgment on Monday.
Yes, my Lord, we are grateful.
Thank you, and I will leave.
Thank you very much, my Lord.